Hi, everybody. This is Richard Bolger. Before we get to the subject matter of the podcast you're interested in, let me tell you I have used a product developed by Anchor to develop my podcast. It's free. They provide tools that allow you to record and edit your own podcast right from your own computer. And thankfully, they will distribute the podcast for you at no cost. So I recommend the product highly. And now let's get to the podcast.
Hello, this is Richard Bolger. I am an attorney in Fairfax, Virginia. I practice law in Maryland, D.C., and Virginia. I practice bankruptcy law in those jurisdictions. And tonight I thought I would give you a very basic discussion, if you will, of the different types of bankruptcy. Primarily, there are 4 chapters of the Bankruptcy Code: chapters 7, 11, 12, and 13. Chapter 7 is called a liquidation. Chapter 11 is a reorganization, primarily used for businesses. Chapter 12 is farmers and fishermen, and Chapter 13 is a reorganization of consumer debtors, subject to certain debt limits. But the basic premise is you have a liquidation or a reorganization when you're talking about individuals. Chapter 7 is generally speaking, the least expensive way to get through bankruptcy. And it is the quickest way and results in a rebuilding of your credit quicker than any of the other chapters. Chapter 13 is a 3 to 5 year long process wherein you are making regular monthly payments typically. Chapter 7 is a 3 to 4 month long process typically, and it results in a discharge that quickly, 3 to 4 months after filing. The only reason typically these Chapter 7 cases go beyond that is if there is an asset that's actually being liquidated in the case. However, most Chapter 7 cases are so-called no asset cases where the property that the person owns who files the case, known as the debtor, during the case we call you the debtor, that person, their property is protected by state or federal law to a great extent. Things like pensions that are, ERISA qualified and so on, those are protected by federal law. And then by state law, you have what is called the homestead exemption we can talk about sometime. That protects equity in automobile, equity in real estate owned by the debtor as a residence, and other things. So Chapter 7 is, as I said, the least expensive and quickest way to get through bankruptcy. Why would someone bother going to Chapter 13 if it is more expensive and much more time consuming? Well, when you consult with a bankruptcy attorney, that attorney, like if you call me, I'm going to analyze your property to see if I can protect it all. And if I cannot protect it all, then I will tell you this property is subject to being liquidated in some manner. At which point you can either elect not to file or to go with Chapter 13, where your property would not be liquidated so long as you qualify for Chapter 13, but you would be put on a payment plan. And people are often asking me, well, how much is the payment going to be? And, that takes a bit of detailed calculating. And yet the general principle is that the unsecured creditors that the debtor has must be paid in the Chapter 13, at least what they would have been paid had the case been liquidated as a Chapter 7. So if, for example, we do a Chapter 7 analysis, liquidation analysis on you, and conclude that there's $25,000 of non-exempt property. That means there's $25,000 the trustee can get at. Then you must pay in the Chapter 13 at least $25,000 to the unsecured creditor. So you divide that by 60. That is 1/60th of your payment right there. And I mean that's your regular monthly payment, 1/60th of the total, plus fees. It's in the cost and the cost of the case. So there we go. Let me do this. Okay, so after the liquidation analysis is done, and if you decide to go with Chapter 13, then you still get the same protections as you would in a Chapter 7. Upon the filing of the case, there is an automatic stay imposed, and all efforts to collect money from you must cease nationwide, and that would mean foreclosures are stopped, garnishments are stopped, and lawsuits are stopped pending the bankruptcy case. So I hope that is a useful explanation of the different chapters of the bankruptcy code and might help you further deciding what might be right for you. Have a good evening.